Yes.
Anything that you guys were talking about?
No, you're also on the record. All right, I call this meeting to order at 11:09 a.m. on Monday, July 22nd. Please keep in mind this meeting may be visually or audio recorded. Okay, I'm going to finish this really quickly. May all the members of the committee please state their name for the record.
Joshua Yachik.
Jackson Ransom, Daniel Weinberger,
Sean Pelletier.
Matthew Brown.
Aaron Rubai as chair. Yeah, we'll slow down after this. May the clerk please introduce yourself.
Oh, hi guys, I'm LJ.
And then members of the public, please state your name for the record as well.
Julia Cypher.
Antonio Hendricks.
Tyler Spark.
Annika Naidu.
Jonathan Chad Stevens. Daniel Belton.
Raj Mia. Austin Britton.
All right, with 6 members present, quorum has been established. Really quickly, do I hear a motion to recess until called back by the chair by unanimous consent?
So moved.
Any objections? Seeing none, the motion passes. Okay, I call this meeting back to order at 11:11 a.m., Monday, July 22nd. Same members are present in the room, plus, please speak your name for the record.
Isha Khan.
All right. 6 members still present. Quorum is reestablished. We are now moving into the consideration of SSB 2024-1428.
I move to move into consideration of SSB 2024-1525 by unanimous consent.
Are there any objections? Seeing none, that motion passes. We are now in line for consideration of SSB 2024-1525, the Fall 2024 Senate Reapportionment Act. All right. So, I lay the committee at rest. So what we're going to do is like 10 minutes of discussion. So the bill that I submitted is a framework. The only thing that we cannot change are the dorms. So the dorms are correct. The number of beds have not changed. This is the same as the injunction that was issued last fall. So no dorm can receive another seat or any less seats. So the dorms are checked out. What we'll be discussing today are the potential models for an off-campus fall election. All right, yeah, so we're at rest right now, so do you want to go? Any ideas?
I was going to say, did you want to start considering you submitted this, discussing where you're at, and then we can go from
Yeah. So I have a presentation that I will give during the presentation period, but the 3 that I have either thought of or have been suggested to me up to this point are a district model, an off-campus model similar to last year's injunction, or a proportional model. Those are the 3 that have been suggested to me. Now, there are different varieties of proportional models, and I want to get into which one of those, because I assume that'll be suggested as well. So I want to know exactly what that means.
Okay, personally, I'm leaning towards the district model, because I think I see like the least path of resistance in terms of legality issues with it. I know your concern was data related. Okay, so I was going to say, can you elaborate on what you mean by that?
Yeah, so I will go over all of the data as well during my presentation, but basically, and this is available, and none of you have to be FERPA trained because it is just the zip code data. So I'll get into this, but the gist is that from the registrar, from the data that was submitted to, I believe, Judiciary Chairperson Emeritus Jonathan Chant Stevens last year in the spring. Is Emeritus the correct? Mm-hmm. Okay, yeah. So it's the same data from spring 2023. It includes the zip code for all of the local and legal addresses of every student enrolled at UF. So there's a total of 58,404 students, and it breaks it down by zip code specifically. And I will show that because I'm allowed to, which is really cool because I didn't think I would be. But basically the problem is, also I'm going to point out that I will end this discussion period at 11:22, just so we all know. That only 28% of off-campus students have registered an address within Alachua County based on this data. And I'll show you how I got that. I have formulas, I have charts, but it's only 28%. So the reason I'm concerned about this for any sort of, we got a whole setup.
Our caucus had very extensive conversation about apportionment.
This has been keeping me up for a long time. So, the issues are, there are a few potential solutions that have been proposed. One is, go back to the districts. First of all, last year's model was deemed unconstitutional, partly because of the discrepancy between the number of students that would have been in District A under the apportionment model and who were in District A.
Can you, when you say that, can you elaborate on, do you mean, was that the version submitted by Brinkman? Was that the version that was in the?
That's the
fall
version
22?
currently in the codes,
Okay.
because it did pass. So, yes. Yeah, like you can, it's 322 point variety of stuff, but it's there right now if you want to see what it looks like. I'll go over that data as well. Another suggestion was you pick the last ending digit of any zip code and randomly assign that to a district. That has been suggested by more people than I wanted to count, but the issue with that is because we have such a small sample size of registration in Alachua County, is we would probably be misrepresenting the size of the actual districts through that model. Because, say for example, there are 10 ending digits that you could have. Say you give 4 to A, 4 to D, 3 to B, 3 to C, or however you arrange it, which I believe that was the version, is that in reality, that would create a discrepancy because we don't actually know if these students, we don't know if the unregistered local zip codes are actually in District A, District B, District C, District D, whatever. We don't know where they are. So the problem is we can't randomly assign stuff because it would likely infringe upon the fact that these students have to vote for their own representatives, and if they didn't live in their own district, that would create complications. You're welcome to speak as well.
So basically, like, what they're saying is that anyone who has, like, the correct address and the correct data falls into one of these district categories. And then, because you said we do have the numbers of how many students are being represented currently in those districts, and then those who don't fall in those districts vote on an at-large, for an at-large district. Since we are supposed to be reviewing apportionment on a yearly basis anyway, we would be able to reasonably, from what I'm gathering, we would be able to reasonably match it up every year to what the breakdown of students is. So
Yes.
that way we are honoring those students who were able to put in their things correctly, but we are also accounting for those who didn't.
So that was the first idea I had come up with, and I was advised that that would create problems with overlapping districts.
Okay.
Because students living within the boundaries of one district would be voting for an off-campus at-large seat. So they should have direct voting capability for their district that they live in.
But aren't we sacrificing that by moving to an off-campus model in general?
There's no more overlapping districts. There's
Yeah,
one.
but aren't we sacrificing their right to, I don't find that to be compelling. I also wanted
Overlapping
to
districts are
ask-
just in general illegal.
There was something else that you said that I wanted to ask about. Okay, can you elaborate more on the data? I know you said 28%. So you got this from the
Registrar's
from the
office.
registrar's office. Okay. When did they provide you with this data?
I believe in the spring initially, and then I requested if there was any more to be provided. They said no, and it was resent to me again in its original format, so I could share that.
Okay.
And that was sent, I believe, last week to me by SGAO.
Okay. Have you, in the past, when things like that have occurred, all like the first set of data being given has been kind of like what you were saying, is messy, terrible, but then upon request, there are more comprehensive sets of data that reflect more accurately what addresses are upon further digging. That's something we've seen in the past, and I'm wondering why that isn't the case here.
What are you asking for by
I
more
think
specific? Because these are the zip codes, and this is how it's been reapportioned. Are you talking about specific addresses?
Yeah, no, I'm talking about the
Like-
fact that upon, first, I don't know what you want to call it, delivery of this information, this data, I agree is not the cleanest, but then there are other records that upon request, which I was asking if you had requested those, could reflect more accurately what the addresses are in these documents.
So, bless you. The data isn't actually messy. it doesn't lack any information that we would need to make a decision based on where students are living, because it includes the zip code and the number of students who are registered to it. If you want more specific addresses, first of all, that is FERPA protected, which is
Well, the full address isn't for protection. You can have like the full home address of where they live and games on.
I do believe you have to be trained for that, though.
MBLs are for the train.
Yeah, because I'm on RNA. Also,
Okay.
I also would like to point out, you have the opportunity to fill out an affidavit at the polling location. So if we are trusting people to put in their information correctly there, I don't see why we have to do away with this whole model. Because there's also no actual accountability there either. Someone, you know what I'm saying, like we trust people to be able to go in there and update their address if they feel that they are voting in the wrong district. And that's kind of why that's what the purpose of that serves. And so I don't know that it's appropriate to just do away with this entire model that serves to give representation to those facing very different problems off campus. I was also going to ask, do you know when the district model began and why it was adopted?
I
think
do.
That would be important for us to consider.
I do. I believe it was adopted in 1996
The district model
or
has been
95.
alive since the 70s.
The one that we have now, the way it's been divided, I believe Brian Burgoon, the student body president at the time, when he was Senate president, was the one who helped, or he was Judiciary chair when he recreated it. But I think the modern district model that we have now is like mid to late 90s is when it was first implemented.
And do you know why it was implemented
I'm not entirely.
compared to an at-large or another model that we were previously using?
I'm not entirely sure. No.
From what I understand, it's because students were essentially protesting and saying they felt that these more vague maps did not represent them, especially as they lived in these farther off-campus districts, like District C.
Where did you get that?
So,
statement?
okay, this is something that someone is looking, it's like in some archive. I asked a couple of different people to see if they can provide it to me by Tuesday, so that I am able to actually give you a source. I also thought this was something that you would be aware of, so that's why I asked you first. But I can provide you with an actual source by Tuesday, because I know it will. I do want to actually give you like a link to something.
Quick question.
Yeah, go for it.
What is zip codes? So you're saying only 25% of the students have a zip code that corresponds to anything in Gainesville?
28% have zip codes within Alachua County.
Okay. And that's all. So the two zip codes that are given for both data sets for each individual person, there's only one thing that's filled out. Because there's two. There's a home address, and then there's a Gainesville address that is listed out. So you're telling me the Gainesville address for over 75% of students is just blank, or just is it
I'll get into
outside?
that in the data. No, it's not blank. It's their home address again. Some of them are license plate numbers. There's a variety of stuff, phone numbers. A significant portion of the student body put XXXXX for their zip code, for their local zip code.
So the argument seems to pertain on that because students can't fill out their stuff correctly, that we should simply throw out the precedence that's like of 30 years. 30 years of precedence that has apportionment going back.
More if we're taking into account just the district model. We're essentially saying that this off-campus or other proportional any type of map is somehow more constitutional than our election maps have been for the past 50 years, which I do find to be a very bold statement.
I don't understand personally how it didn't come up sooner, that we didn't know if these students actually resided in them, how we randomly distributed the zip code ending numbers or a variety of things to make the districts the sizes that they were.
1UF has only existed for so long.
What?
1UF has only existed for so long. People put in this information via 1UF. There's been other procedures for us to get people's locations prior.
Okay.
This
Well, at
is
least in the time
probably-
since we have 1UF, I don't understand quite how they came to these conclusions for the sizes of the districts themselves, because I will get into how I don't understand how they could have came up with a random size based on the data that I have in front of me right now. It might have been different before 1UF, but at least in recent memory, I don't fully understand how this issue didn't come up before, because it is quite shocking. I didn't expect this. When I requested the data, I thought, oh, we might have 75% of students registering a local address in Alachua County.
What's
I
the
was-
current breakdown again? Like, do you know the numbers or just the percentage?
I have the numbers as well.
Okay,
Let's get into the presentation.
Yeah, I'm going to move into the presentation period.
Okay, one more question.
Sure.
So you were given this information back in spring, right?
Late spring, I believe.
Late spring, but traditionally, and I believe per the codes, but our norm is technically that we are supposed to be amending and approving apportionment pretty far in advance. So I'm wondering why this is kind of the first time this has come up.
So I only became judiciary chair in the spring, so this is all I can speak to. Basically, we fell way behind last summer. What we're supposed to do is, before the fall election, reapportion ourselves for the following spring and that subsequent fall election. Now, when I became chair, I realized that we hadn't even done spring yet, so we were already really far behind. So I wrote a piece of legislation that reapportioned spring, like right before the spring election, and this was just to catch up, and that's when I only had data relevant to the colleges, and I didn't quite know the procedure for this in particular because it is so late and this is breaking precedents. But once we passed the spring at that time frame, that far after when it was supposed to be passed, it did set a precedent that we could do this in necessary circumstances where we hadn't already set the apportionment model in the previous fall. So what needs to happen is there needs to be an apportionment for this fall, which is what we're working on now. And then in the fall, there has to be another apportionment for the subsequent spring and fall to get us back on track. That'll get us back up to date to where we need to be.
I would like to say, just for the record, not the literal record, but just like as a phrase, for the record, I do understand the intention of saying, well, in the future we need to catch up, but I also think that we had an opportunity to catch up. Like, just because we've set a precedent of falling behind, which is also because we saw a very unique partisan breakdown of the chamber. That was another big reason. We also had a map submitted in the fall deemed unconstitutional by the Supreme Court, which is also unprecedented. So the idea that we have set a precedent of pushing this back, I wouldn't really say is necessarily true. It was just that unprecedented events took place, which led to that outcome. So I just would like to put it out there that I don't think that that's a reason for us to be bringing up apportionment for the first time, like the second or third to the last meeting of Judish before summer ends. Just to put that out there. I understand you're about to move into presentation, in which I imagine you're about to show us data. Yeah, okay. I mean, if anybody else has anything to say before we move into that, but I think that will also give me a lot of clarity as to what you're actually referring to. Because as of right now, I'm just going off of,
Yeah.
you know, the verbal explanation.
Yeah, it should give clarity.
Anyone
Quick
else?
question.
Yeah.
Just
Yes.
real quick. This is the only chance I have to participate in this process,
Yeah.
so if you don't mind. Are you aware of any other time in history that we've used an off-campus at-large map?
I'm not, no.
Okay, so there was an off-campus at-large map in the 1990s.
Okay,
Are you aware of the reason why we reverted back to a district model after these?
I'm not.
Thank you.
One quick question.
Can I ask a question really quickly as well? You brought up a proportional model to me several months back, and I wanted to get clarity on how specifically you would want proportionality to be done, whether that would be...
Are you speaking to me?
No, yes.
Brought that up?
What?
I wrote it.
Who are you speaking to?
I think multiple people brought it.
Yeah, it's
Pelton,
been brought up.
Nathaniel Pelton. I just wanted to ask, so for the proportional model, there's two that I thought of when I thought, oh, okay, what could this mean? Firstly, it would be that all the voters would vote, and that whatever percent of the vote that they won, that a candidate won, that a party won, the top candidates, until they hit that threshold, would be elected. Or, so basically, say, for example, Party A wins 70%. That means 70% of the 37 seats would go to the top 70% of the 37 candidates that ran under that party name. The other one I foresaw was it being a purely party-based election, where you vote for a party, and the party chooses, based on the people they have on their slate, who they select to be those candidates. Rather than voting for individual candidates, which one were you referring to? Which one do you prefer?
Frankly, both kind of crossed my mind, actually, as
Yeah.
options. Obviously, it's not easy to make a decision between a partisan exclusive and a list of candidates. There's a lot of challenges logistically with that. I would just revert back to the district model. It has been the tried and true method, not only here, but also across the state of Florida, the United States, and in democracies across the world. It's never been an issue in other democracies or places where somewhat incorrect data would somehow completely invalidate the district model. So those are just my thoughts, if you want to
When it comes to the proportional, you're gonna have to make some decisions on the fundamentals. Do you want to have students who live off campus to have a person that directly represents them? right? Instead of just a party, because you could say,
Yeah.
oh, X.
Yes. No, I agree. I just wanted to see which version that was preferred, because I've looked into both of them.
Also, about the numbers that I asked for you before, are you going to be presenting them?
Yes.
Wait, I have some more questions. I wanted to ask you, especially since obviously you're the one who submitted this, which is why I'm throwing you on this,
Yeah.
even though it will ultimately fall on the entire Judiciary Committee to adopt this. This is really open to the entire committee. Do you see any issues with the representation provided by the off-campus map to those off-campus students?
Yes. It's not a perfect model whatsoever. I'll admit that fully.
But can you explain to me what you think those problems are? Because that will help us.
I mean, the
address
problems are the problem experienced in an off-campus, not an off-campus, but an at-large election in general.
which are.
That the vote isn't necessarily representative of the voting breakdown of the constituents themselves. But I'll get into that as well. There are flaws with every single model we've talked about, and I'll admit that immediately. That's very clear. I wasn't initially, and I'm still undecided, but initially I was, like last year when this was an injunction, I was very confused. I was quite shocked, honestly, that this is what it was switching to. Mostly because I had no information, and that's what I'm trying to get into today, is just to illuminate the information behind it for those who don't know, so that they're aware of the pros of models, the cons of models, why that was decided last year, why we had districts before, all of that. So that was why I didn't fully understand last year, and I hope that I can make it so that everyone in here can understand what's going on.
From what I'm understanding, are we at the point of like trying to find a middle ground between the district map and the off-campus map? Or is there one that you're kind of already choosing?
I think it has to be, it couldn't, a middle ground, I'm not sure.
I'm just trying to interpret what you're saying. So
Oh, no,
you
I
feel
think
free.
we would have to select between them.
So
It wouldn't
is
be a
there-
combination.
Given that you've kind of just told me, well, there's flaws with both.
Yes.
What are you currently leaning towards?
Currently leaning towards? I'm going to present the data and let the
Let's get
committee.
into the presentation.
Yeah.
Let's talk
Okay, so my
That's-
final thing I would like to say is that when you do get into presentation, pro-con discussion, there is nobody from the minority present today.
Okay.
I understand.
I'd like to address that. She is out of town.
That's true, but this could have been done at any meeting for the past 4 months. So I do want to, just put that out there.
According to the rules of procedures of the Senate, the committee will begin drafting apportionment legislation no earlier than the start of the summer A term, so it kind of.
That doesn't apply, actually, because that would have been for a year in advance. That's how I initially interpreted it, though. So when I wasn't doing this, when I was like, oh, I have to hold off in the spring, it's because I thought that applied directly to what we were doing now, which is a reasonable assumption to make, that you can't begin drafting until summer A. But this is a year late, which at the time I didn't understand that we were that far behind. So I thought, because I thought this was for the following, not necessarily for
That
this.
That does not apply here.
It does not,
The
no.
rule that was read out actually doesn't apply.
No, it
So
does
my-
not.
Okay, so I do
So-
understand your misunderstanding, but I would like to say my point does still stand, that this could have been done.
I fully understand wanting a minority voice. On the other hand, I'd love to have Adriana here, and like, there's no intention to exclude her.
Yeah.
Voice
No,
in
and
here.
I'm not insinuating that, I'm just saying, I just wanted you guys to keep that in mind, just because that's why
Yes.
this period
Yeah, of course.
is so important for us.
Yeah.
Absolutely,
I'm
that's
really
why I'm
glad-
doing this period.
I'm glad you all came to voice your opinion now, because I want to have that opinion.
Yeah, I only have a couple just technical questions. Number one, did you look at any Florida case law when I was drafting this apportionment model?
Florida case law, yes, but yes, I did.
Gotcha. Did you assess any of the model via the compactness test? Any of those like cases?
No, I have not.
Did you assess any of the cases through the existing political and geographical boundaries? Did you evaluate any of those off of those
Yes.
models? You did. Did you evaluate any of them based off of nearly equal as practical
Yes, I did.
doctrine? Okay. Let's move on.
Yep.
I have nothing else to ask.
In the event that after your presentation, we have something to add or to say, is there anything that we can do to actually talk about it?
During
Because I do question the decision to have this rest at ease or at rest, even though I am, thank you for giving us a chance to speak, but doing this before you presented the data. Because now we can't actually, I feel like we're talking in circles because we don't even know the data that you're referring to.
Okay, so the point of this was for discussion about possible, I will go over this. It was for the committee in and of itself has to be, this was a big part of the Supreme Court case. The committee has to draft the legislation, as a committee. So for this, it's edification for the committee members on the possible models that we can evaluate between. If we were to do it afterwards and that's before voting and all of that, then it's no longer the committee drafting this legislation. So for me, this is a bill. I'm not gonna, this period before I'm treating differently because it is in the best interest of the student body for all members of the committee to understand what is going on and what exactly is available to us. But if we were to include a section like this before voting, that wouldn't make much sense, and I think it wouldn't make sense in the context of evaluating legislation because this is a bill. And I've never done that for any other bill. This has been an exception, but you see why I'm doing it. And
We actually did do this for the RNA, the FAST bill, with the criteria on RNA.
to amend it, I
And then we
believe.
also did that
I believe
with
that was to
the
amend.
thing about when city officials come and speak at the meetings in judiciary. The committee was put at rest right before the vote.
Okay.
All right, does anyone else have anything to add?
I mean, are you willing to put the committee at rest? Because I definitely understand what you're saying, but we're also not the ones that are voting on this bill, you know what I mean?
Yeah, I mean, this will also come to the floor. Whatever model passes, that is the chance. Committee meetings aren't designed for this. This discussion is good, and I think we should be having. That's why I created this whole discussion period. But no, I'm not open to laying it at rest again before a vote is decided. I think any other things you have that have to be discussed about the legislation can be discussed on the floor.
Okay. Also, why are you Senator Rubai and not Chairman Rubai
Where?
on this bill?
I have no idea.
It doesn't matter. Let's go.
I just put senator, I guess. Sure, yeah, go
I'd
for
like
it.
to
This
be
is the
here.
last thing, though. This is the last.
Yeah.
I just, since that data is
I have to, so I want to be able to talk about
It's going to be on the screen.
What time do you?
Okay, no, but can you share
As
the file?
I
Or,
don't know, but I
so,
think so. I will check with SGAO.
12:20.
To see.
Yeah. I want to be able
Um,
to hear. Aaron, we gotta get into it because we have to.
Okay. Yeah, we're gonna do it. All right. So. Okay. So. Can I make this full screen somehow, or is that just not? This needs to be full screen.
If we turn off the lights right now, will it show?
We'll see.
I mean, well, if it shows fine.
Yeah.
Okay. Yeah, we're good. We're good.
Does that work? Everyone good? Okay. Now moving to 5 minutes. Can you keep a timer?
Yeah, sure.
Of 5 minutes of presentation.
Is this presentation per slide or total?
Total.
Okay.
5 minutes beginning now. All right, so here, just so everyone sees it, is a map of the zip codes in Alachua County. Because not many, this is actually a really difficult map to find. It took a while, but it's a useful map. This is where the university is. And you'll notice that the district model beforehand included 32607, 08, 01, 03, specifically by their zip codes because of their proximity to the campus itself. You'll notice that they also go, 32601 goes way off campus, so does this. Anyway, because I have a lot of stuff to present. Okay, this long list is the data. You've seen this before. I believe you could verify it at some point after, but some important characteristics. I actually don't know if I can show. This is the number of students who put XXXXX. This is the total. This has not been altered, just so everyone can see that, because I use this number in further calculations. This is local, legal. So going into the local address breakdown. This is the total student population, formulas at the top. This is the number of non-local, non-Alachua County zip codes. This is the number of Alachua County zip codes. 35% are registered in Alachua County for their local address. So I realized that this included zip codes because Alachua County zip codes include zip codes where students live in residence halls. This is the number of students, and this number is slightly larger than it actually is This is zip code 32601, 32612. 32612 is where the residence halls, a variety of them are located. There are also an increased number as well. In other zip codes, like Quarry Village, which is in 32603. So this number is actually probably slightly greater, but it's close. This is the percentage, and this is a maximum. It's not any larger than this. It can only be smaller. 28%, you come over here to the students that are registered in Alachua County off campus here, and the number of students not registered. So here's the breakdown of that. 28% of off-campus students are registered to a zip code contained in Alachua County. So you can see that. That is where I got the numbers from. That's the breakdown. So I'm going to go into the district model from last year that was deemed unconstitutional. So the issue with this is, according to the court, misrepresented District A. The problem was District A included all other zip codes not included in B, C, and D. So this is the number of seats that would have been had this model gone into effect. Because essentially it created a District A at large with, it was very close to the off-campus model itself. It was just, I don't know how they got these numbers. That made no sense to me, and the Supreme Court agreed. So now we're going to go into SEC schools. So when doing this, I was looking at what different SEC schools do, because I think it's important to look at peer institutions and figure out how exactly their senators are elected. I found out that most senates are much smaller than ours. Most of them only have one election a year, and usually they're by college. There are very few exceptions to this. They're all by plurality. Some have appointment, which I found quite shocking, where you can appoint senators. The few that have residences listed as a essentially area to elect representatives from are Texas A&M, University of Tennessee, and I believe University of Texas, but I didn't write it down. So in these two examples, this is dorm residential, and then they appoint some at-large. This is directly from each of their constitutions. So like it's, yeah. I formatted it, but it is like you can check this in the constitutions. And then University of Texas A&M University, which is the only other residential one, uses a single off-campus at-large model. That is the only other residential one that uses residences as a basis of the election. So going into proportional model, so here are some of my primary concerns. And if you go through this data here, the percentage to win a majority in the Senate in the fall election would be 38%. It means a 38% vote could win a majority of seats in the fall election. It's also because of, okay, I'm just going to go into more. Now this is also true with the off-campus model. The off-campus model, 42% vote could win a majority of the seats in the fall. And these are hypothetical examples, the minimum votes. These are both, like this vote total would never actually happen, but I want to go into it. And that's time. So, okay, so if someone asks me to explain a slide, I can continue explaining a slide. So I would ask that you ask me about these two. So we're now beginning 5 minutes of Q&A. The committee made the decision last spring, this past spring, that we do not extend or limit debate time or any other time outlined by the codes. We have it done in a single time. 5 minutes of Q&A starting now.
Can you explain that slide?
I can, okay. So what this, and I'm going to explain, yeah, this one too. So I'll explain this slide. Basically, the reason I say that this is an issue is, okay, this is assuming, yeah. Sorry, it's not the cleanest Excel presentation, but anyway. So basically, 38% of an electorate electing a majority in Senate. This is an issue for a couple of reasons. This is assuming the model selects the top candidates from a party based on the party's percentage winning votes. The top candidate is the percentage won. So, for example, if Party A, I guess this is Party A, won 40% 40% of the off-campus election, their top candidate won 40%, then they would be afforded 40% of 37 seats, the top candidates from the party selected for this. Now, the issues I see surrounding this are suddenly we're no longer electing candidates, we're electing parties, which I think is generally a bad thing, and I think most people would agree, that students on campus want to vote for individuals that they believe will serve their best interests and their ideas, and they don't want to vote for a party, they want individuals. So that's why I think this is a problem, because some of the candidates that won by a majority vote would lose in this election model because of the party that they're affiliated with. Furthermore, if off-campus students vote 37 times and say only 25 of their votes counted towards their elected representatives, now all of a sudden we have huge issues with what was brought up before, nearly equal as practicable. Dorm seats already get more representation per person than off-campus seats do. That's the nature of our Constitution. It's a good thing. It helps protect the representation of dorms, which we need. We need a candidate per dorm. But if we made this divide even greater by further lowering the number of votes that counted per the off-campus constituents, this would be a problem, and I believe it would violate that clause. So those are three issues I see with this model and why I incorporated this here. I included this based on past election data. This is just that this outcome could have happened, I believe, 4 times in the last 10 years with less than a 200 vote swing. And that is important to bring up, because this model as well has its flaws, and that's the end of that question, so I'll get into this as well.
Would you like to talk about the off-campus
I'd
model?
love to. So this model is also not great, because it does increase the number of seats given, even if a minority of the electorate votes for it. In this case, 42% vote is needed to attain a majority. That is a problem. However, this is less likely to occur in reality. And keep in mind, I tried to limit my analysis of any election data as much as I could to go purely off of the population in districts, but I feel like this is an important note to make when making a decision, is that it is highly unlikely. This assumes that the party who wins off campus wins 0 dorm seats, which is, it's unlikely that in an election a majority vote would not include, for some example, just any dorms. That doesn't make any sense. But again, I'm trying to stay away from this as much as possible. This is a little add-on. This is not the premise of the argument. But this too is flawed, because the minority can still elect the majority. It is just less extreme. What this does do is it ensures that all of the votes are as equal as practicable. The Supreme Court ruled the same way, that if there is just one singular district, that the votes are inherently equal to each other, which is important. Does someone want to ask me about this slide?
Yeah, can you present that?
Yeah, absolutely. So here's, I'm going to use a different slide first. So this model, to me, what this data suggests is that we cannot extrapolate based on this data the actual, in reality, population of each district, which means that in apportionment, even though we may select a size, we talked about people at the polls updating their addresses, but when we're creating the map, we don't have that available to us, and we have to apportion the seats on the data that we have right now. So I understand that addresses can be affirmed at the polls and at the voting booth, but we can't use that now, so I don't think that's able to be discussed. But basically, this is, the district model just has so many issues with what we currently have, and the fact that we're missing so much local residential data. That is time. Whew. Okay. Go back to map. All right, we are now in line for 5 minutes of debate beginning now.
The one thing I'd like to talk about for the most part is the concept of electing parties instead of individuals. I think electing individuals is incredibly important. I think we see voting disparities happen all the time between individuals in one party and a different individual in that party running for, say, a different race. We see it happen at the local level, at the state level, at the national level. Just an example I have here, like a statewide election in Ohio last year, we had a gubernatorial candidate win by 26 points. a Senate candidate win by 6 points, right? Things like that happen all the time. And the same is true here on campus. We've had candidates from parties who will get hundreds of more votes than somebody also on the same slate of that party. It's because people want a specific person to represent them. And I don't think that essentially ending ticket splitting as an option, I don't think that should be a thing. I think we should have the option for voters to ticket split if they would like, based on what individual person they'd like to represent them. So.
Yeah, I completely agree. I have another table from another school student government. I like the proportional model. I like the idea of it, but I completely agree. I don't want to move more toward party voting. Like UCF, I was really struck they don't have parties. Each candidate runs individually. Okay, my bad. But I feel like a lot of what we do is party based, and I don't think that should be reinforced through further reinforced. I feel like we should empower individual candidates to campaign and talk to their constituents and really work toward getting their constituents to vote for them specifically, not for their party. And so I see the merit in not reinforcing party voting.
I want to talk about districts really quick. I believe that's what has been talked about most. So the way I like to think of it is kind of the United States map for the elections with the electoral college of votes. It's very similar to our map. We know the entire population of the United States is about 330 million. If we knew the entire population, then we only knew a few states. It wouldn't be fair if we just drew up lines on a map and to where we thought the population is going to be equally represented, which is essentially what we're doing in districts.
Is there any more debate?
To add on to what Senator Foster
I'm
said.
going to ask that only the
Yeah.
committee members can speak during debate. Thank you.
To add on to what Senator Foster was talking about with, and actually everyone has mentioned the importance of individuals being elected by their constituents. I don't think an at-large model limits this at all. You still have the chance to meet and decide who you think best represents you, and I think that's definitely the best way to do it, especially because it keeps all votes having equal weight.
To piggyback off of what Senator Bravo said, I really liked how he highlighted the ability to split your ticket, the ability to find one candidate more preferable than the other, and I think that that's something important we should keep in mind.
And just because based off of the discussion we've had earlier, I hear people's concerns with that large model, but from what all the data that's been presented and what we know about the addresses, actual information we get, where people live and the addresses that we have, I don't feel comfortable moving toward a district model. Again, at least for now, maybe there could be changes so we have more concrete data in the future, but from what I've seen today and from what Chairperson Rubai has presented, I feel like an at-large model is a better model that we should move towards for now to make sure that students can get the representatives that they want. And like we talked about, ticket splitting, all those things will still be part of the model moving forward for this year.
I agree with Senator Falseri as well as actually everyone on this committee. I believe, yes, I see the fallacies with all the maps presented. I believe that this is the most democratic solution.
I agree with what Senator Falseri said. I think that the data really illuminated the case for me, at least.
I just want to harp on one more thing, just talking off the passion point I have for it, which is split ticket voting. I think that it was we have the prior fall election. There was a candidate from one party that received nearly 400 less votes than the candidate at the top of that party. And that is important because that person who's at the top is clearly the most favored candidate. And this was another off-campus example. They're the most favored candidate by those voters. So that's going to be something that I think we should take into account, who the voting public wants specifically as individuals to represent them.
That is time. All right. So, really quickly, because we do have to, whatever we decide, we have to amend the legislation that was submitted. So, really quickly, do I hear a motion to recess until called back by the chair by unanimous consent? All right. Any objections? Seeing none, the motion passes. Why does this stop? Okay. Call this meeting back to order, 11:58 a.m., Monday, July 22nd. There are still 6 members of the committee present. Members of the public have not changed in composition. All right, so we are now in line. We've just passed through the, I guess it's final privilege now. Okay. So, I think that given the fact that as of right now we do not have conclusive data as to the actual composition of the Alachua County student population, that it would be prudent to use an off-campus model for the fall 2024 election. So I waive the rest of my time. All right, we're now in line for any motions at this time. Okay. We can, I guess, speak freely about things that don't apply. Okay.
We're looking at like 322.3, right?
Yes, 0.31. Okay. So I guess, do I hear a motion to amend SSB 2024-1525 to strike the list of the zip codes for each district?
So moved. Oh,
Are there any objections? Seeing none, the motion passes. Let me fix this. Do I hear a motion to strike 322.311?
So moved.
Are there any objections? Seeing none, the motion passes. What else applies? Okay, do I hear a motion to strike in 322.32, beginning at the comma after order, all the way through the period after A-07 parentheses period by unanimous consent?
so moved.
Are there any objections? Seeing none, that motion passes. Do I hear a motion to strike the word districts in the second occurrence of the word district?
So moved.
Hold on. Do I hear a motion to strike the words in districts and districts in 322.31 by unanimous consent?
So moved.
Are there any objections? Seeing none, that motion passes.
After you guys amend it, can you put it on the board so we can see it?
Yes. Well, it's going to be sent out
I know, but
today.
just for, because I like, you don't, like, I can't read it twice because you're saying.
Okay. Okay, so that's okay. Do I hear a motion to add underneath the previously stricken list of districts the language off-campus, colon, and then the however many dots are in those 37 by unanimous consent?
So moved.
Are there any objections? Seeing none, that motion passes. Okay. Okay. Who does that? Okay. Do I hear a motion to amend SSB 2024-1525 to replace the word district with constituency? Rescind that. I remake that motion except with the word location by unanimous consent.
So,
Are there any objections? Seeing none, that motion passes.
what?
That's 322.12.
Okay.
I remake the same motion for the word district in 322.11 by unanimous consent.
So moved.
Yeah, I don't remake the motion. All right, do I hear any motions at this time?
I move to pass SSB 2024-1525 by unanimous consent.
Are there any objections? Seeing none, that motion passes. All right. Do you have to leave?
Yeah, I'll approve.
Okay. Who else has to leave?
Probably even 15.
15?
minutes.
Okay. Alex is coming? Okay. You can leave if you have to.
Can I do mine?
No. Okay. Are there any? Yeah.
Okay. I now move into the consideration of SSB 2024-1513 by unanimous consent.
Are there any objections? Seeing none, that motion passes. We're now in line for the consideration of SSB 2024-1513. The author, Majority Party Leader Cipher, you have 5 minutes to present. Okay. Yes, yeah.
$15.23.
1513.
Okay, sure.
Alrighty. Okay. Please state your name for the record.
Alex Rooks.
Alex, you can take my seat.
Alright, so Senator Judiciary Member Weinberger is leaving, so there's still
I wanna
6
stay
members.
I want to stay.
Okay, so you're still here. Okay.
I wanna hear.
There are 7 members present. Okay.
Don't want to move over. Can you just get that to me another day?
Oh, the jacket, yes, thank you.
Okay.
Appreciate it.
You have 5 minutes whenever you're ready.
Okay, I'm ready. So basically what this does, SSB 2024-1513 and 1514 are essentially doing the same thing. And the reason why this amendment is being made is to repair an issue that we saw this past school year where state law acts in the codes were not the clearest. It was illuminated during the censure hearing that both Accent and SGP use a third-party agent who does an extensive background check. I'm assuming it's an electronic background check, but basically for background checks, you need to go through records and have clear defined measures as to what exactly you're looking for. Otherwise, any type of computer system is going to overlook certain things. And so what we did here was make specific or add the specific legal terminology that we believed was appropriate for what this bill was trying to accomplish. And that's kind of the reason why we authored this bill.
I guess I can speak a little bit too.
Yeah, sure.
Yeah,
I'm willing
yeah.
to take any questions. I just, this bill essentially is just fixing an issue that I believe that everyone is under the same understanding. It needs to be fixed within the codes.
Alright, so yeah, there's As for what specifically the threshold is to prevent SGP and accent from entering into contracts with these individuals, that's being discussed, and I think that's a fair discussion to have about where the line needs to be drawn. However, based on specifically what we saw in the spring with the joint censure hearing, there was an issue of a lack of clarity within the codes, and this is specifically on us. So if we want to talk about prohibitions for entering into contracts, and we have a threshold of reasonably compelling evidence, which isn't specifically defined, and the chairs of these organizations do not have legal experience. They don't really have, this can be interpreted different ways. So in the future, I want the threshold to be very exact as to who these chairs and organizations can and cannot enter into contracts with. As long as it's specific, we can hold them accountable. Where there's interpretation, it leaves room for error for the codes not being followed in the future if a breach of this code is committed. I think this is a great code to have in our governing documents. I think it's necessary to have some oversight. But I do think the line has to be very specific as to who can have a contract or not. That way, we can fairly evaluate whether or not the code has been broken if it does come down to a censure or a joint committee hearing. So, but yeah, as for the threshold itself, there have been suggestions thrown out. I think evaluating those is fair, but purely from a standpoint of clarifying the codes, I think this is a good idea. I wait the rest of wait the rest of my time. Okay, we're now in line for 5 minutes of Q&A. Whenever you are ready.
I have a question.
Yeah.
You don't have to go into like extreme detail, but can you just kind of explain how the wording changed from the prior to the current?
Yeah. You can answer it too. You can answer if you'd like.
Can I see whatever version of the bill you have? My phone is not good with this. So basically, so moral turpitude is struck because upon further investigation of what exactly moral turpitude is, not all of the things that are considered moral turpitude falls under the general idea of what this is trying to get at with various things related to SA and dating violence. But as for the actual changes in wording to 220.83, before the wording was reasonably compelling evidence to assume that an act was committed. Everyone as an individual is able to look at evidence and come to their own conclusion, but we changed the wording to has pled guilty, pled nolle contendere, or been convicted of, just because what is reasonably compelling, that could mean different things to different people. Someone with either little to no or a lot of legal experience can look at the same evidence and say, well, I don't think that something is reasonably compelling unless they were actually taken to court and found guilty. And that was the distinction that we were trying to draw, because during the censure hearings, numerous mentions of potential SA cases on Wikipedia or other sources that I don't know of indicated to certain people that there was reasonably compelling evidence, but to others maybe not so much.
Thank you.
Are there any more questions? Seeing none, we're now in line for 5 minutes of debate. Beginning now.
I agree, to be honest. It's not, we're student senators here at the University of Florida. It's not our job to be checking, be making decisions on the legality of such things. We're not trained to do that. We're not in the job to do that. So I believe that this is constitutional and it's valid.
Yeah, I agree. The have reasonably compelling evidence is very subjective, and it feels weird to give SGP an accent, judge, jury, and executioner roles to decide if someone has done this. Of course, I don't think we should hire anyone that has, but I don't like the former. I like this one. I think we should pass this.
It's good, yeah. I agree with you. No one obviously is seeking to do that, to bring people to campus that have criminal acts, obviously. But it's good to be specific. And this will prevent things like that from happening. So I think it's a great idea.
Is there any more debate? Seeing none, we're now in line for 2 minutes final privilege, whenever you're ready.
I can just speak on this really quickly. I know your job isn't to debate the exact wording of this bill, which is why I didn't go too in depth into what the other suggestions are, but some other people have thrown out there that potentially we could include settlements in this piece of legislation, also potentially ongoing court cases, and that's a conversation that myself and Minority Party Leader Naidu have been having. And I'm not gonna, I guess, take a stance on them now in Judish because we've been having those conversations, but I expect that we'll either talk about it on the floor or this is going to pass by unanimous consent. I waive the rest of my time.
We're now in line for any motion at this time.
Move to pass SSB 2024-1513 by unanimous consent.
Are there any objections? Seeing none, that motion passes. We are now in line for consideration of SSB 2024-1514. This is the second volume of the same act.
Point of inquiry.
Yes.
Since it's the same bill, do we still go through all the same? Like basically,
Yep.
it's essentially the same.
Yep, different bill. All right, 5 minutes of presentation whenever you're ready.
I can just go ahead and waive my presentation time. It's the same thing.
All right, we're now in line for 5 minutes of Q&A. Are there any questions?
Just because now you have time to speak on it, I'm just curious what exactly like you're talking about with other like settlements. Like, just can you just go more in depth about what you're talking about?
Yeah, okay. So the whole point of this piece of legislation is to prevent people who've either pled guilty or pled no contest, preventing those people from being brought into campus by both Accent and SGP. As for ongoing cases, initially I was like, okay, I generally agree that just to avoid the drama in general, that shouldn't necessarily be brought in. But I believe we as Senate have a responsibility to codify something that is just generally really specific, and cases can be ongoing for years.
Mhm.
Also, you can go into cases charged with one thing and come out with all types of other different sentences. So for that reason, my personal particular stance was, at first I was like, yeah, it would be a great idea to include ongoing cases, but now not so much. And then as for settlements, so that's kind of a tricky one because it was brought up that sometimes people who are like in the entertainment industry who are super wealthy can like essentially settle when they're being accused of any of these acts. And in exchange for a large sum of money, you know, the case would no longer continue. But in my opinion, you know, a settlement, not even just necessarily for this issue, but just in general in a court of law, a settlement doesn't really equate to a guilty sentence. And so also there's a potential issue of like discrimination between certain people because some settlements are private, some settlements are public, some settlements you have different information as to what exactly you settled on. Some settlements you have no idea what was settled on and you just know that some type of agreement was met. And so for all of those logistical reasons, while I do agree that all students have the right to essentially protest certain speakers or performers that they wouldn't like to see, I do think that settlements don't necessarily need to be included within these codes. And I think that this does a really good job of preventing people who actually have been found guilty of doing these things from coming in. And I'll keep my personal opinions out of it as for whether I personally believe that anyone with, you know, a settlement for any of these acts should be coming into campus. But there's a difference between personal opinion and what we as senators have a responsibility to codify.
Thank you.
Are there any more questions? See, none are now in line for 5 minutes of debate.
Just really quick, I feel similar as I did last bill. I think we should pass this. I just want to comment really quickly about, because we saw a similar bill before, and I want to, like, kind of what you stated before, like, as senators, we need to codify specific, like, cases, and then we need to trust that our chairpersons will make smart decisions outside of it, and I feel like this is a good job at, to, like, with SGP and Accent. will make smart decisions when bringing in people, and I think this does a good job, and the last bill does a good job at just outlining a framework and then giving them a fair amount of trust to bring in good people, and hopefully they will do so. But yeah, I like this bill.
I support these changes just like I did for the prior bill. I think we should pass it.
Is there any more debate? Seeing none, we're now in line for 2 minutes of final privilege. Whenever you're ready.
Yeah. So I do just want to say that this is a particularly sensitive topic. You know, like ideally we wouldn't be debating this on the floor at all, or at least for a very long time, just because, you know, it's a sensitive topic that I personally don't like talking about. I know many other people in the chamber who should be there for attendance and for votes may not want to talk about it as well. So I did all that I could, I guess, before to get everyone's general opinion. I submitted this legislation earlier over the summer, I think at the very beginning of summer B, then withdrew it so that we could have more time to talk about it. So the hope is when this gets to the floor, there will be no debate. If there is debate, that's okay, because debate is allowed on all bills, but and then also, I think that people are well within their right to protest any accent or SGP shows if they don't like to see the speaker or performer, if they disagree with it on like a moral level or any other type of different standpoint. People have done so in the past with protests, like in person, on campus, online, whatever. It's something that's happened all throughout history, and you know, I still think that people should be able to do that when it's related to these particular things, if they disagree on a moral level with any type of speaker or performer. I waive the rest of my time.
Now in line for any motion at this time?
I move to pass SB 2024-1514 by unanimous consent.
Are there any objections? Seeing none, that motion passes. Go for it, Karen.
I now move into consideration of SSB 2024-1520 by unanimous consent.
Are there any objections? Seeing none, that motion passes.
Can I just say something real quick before I leave? Can I say something?
Wait. Do you want me to?
Thank you guys for coming in and talking about these issues. I appreciate it. I think it's good that we all got to hear everything you guys said. I know we have some disagreements, but I value you guys being here. So I appreciate it. Keep up the good work, everybody. If it's still going on, I can come back. I'll be gone for like an hour and 15 minutes. I don't know.
Okay, I don't know.
So,
Unless y'all are going until 3:45. Yeah, I'm here.
Yeah.
Also, Austin, did you have anything else you wanted to go over? We got to everything, right? Okay, all right. If anything else, just let me know.
All right, thank you.
Well, let me give you your jacket back before we leave. All right, I'll see you.
See you later. Alright. You are still in order.
Does anyone want these? Does anyone want plantain chips? I don't want some. You want?
Yes.
I don't know. My bad. It's okay.
Okay, so we're still at order. We're in line for SSB 2024.
Can I ask just a quick question? When are you, like, when does this end and how many bills do you have to go through? I'm just curious.
So we
I
have,
have to leave after like the next two bills.
Okay. I was just curious.
yeah, this was a difficult meeting to schedule. There is a lot still listed on the
Okay.
on the
I just don't
doc.
have access to the list or something. No.
Yeah, I believe there's something like
Okay.
30 something.
Thank you.
There's a decent, yeah. Unfortunately, not everyone is available for very long today, but wait for as long as we have quorum. All right, we're now in line for SSB 2024-1520. Seeing as there is no author or sponsor present, we will move directly into 5 minutes of debate. Okay, so I see what this is trying to do, address an issue that we've had recently. I hope everyone else in the room has this bill up as well, because I think this is a good change that we should have to make it at least more clear about constituency, especially for graduate constituency. So this is adding that.
It's your requirement.
Okay, so this makes it clear that there have to be two different requirements. This is just clarifying this. This was submitted directly by the Rules and Ethics Chairwoman. So I do believe that has some weight. I think this is also reducing the number of graduate student organization meetings that grads have to attend to complete one of the requirements for their constituency, which should alleviate some. I know we've heard Adriana speak before about some difficulties attending certain events due to research presentations or a variety of other reasons. I think this is a good thing to decrease that. Yeah,
Are we in debate on it?
we're in debate.
Yeah, do you want to speak on it?
Yeah, I mean, I know we've had a lot of issues in terms of clarity of what graduate students actually have to complete in the chamber for constituency. And it's been the sort of thing where the Rules and Ethics Chairwoman has been operating on a more lenient basis, and this just sort of codifies this so that there's no, I guess, disconnect between the senators and the Rules and Ethics Committee. This is just a really good change to make.
Yeah. This just feels like clarification. I don't see any reason to not pass it.
I mean, I want to echo that this really is more like just, how do I say, standardization. As senators in general, not graduate senators currently, we have to fulfill 2 constituency requirements. And this just makes it so that graduate senators have to do the same exact thing as we do. This is really, I don't see anything wrong with this.
Cool.
Is there any more debate? Seeing none, final privilege is waived. We're now in line for any motions at this time.
I move to pass SSB 2024-1520 by unanimous consent.
Are there any objections? Seeing none, that motion passes. Oh, shoot. We're now in line for, sorry, I accidentally closed out the folder. SSB 2024-1521. You are an author on this piece of legislation, so you have 5 minutes to present whenever you are ready.
I'm not ready because this is what it's showing.
You want to look
So
at?
I'm gonna come
Yeah.
Yeah, okay. Let's see. Thanks. Oh, okay. So, yeah, this is actually a big issue. And we were just facing it. Basically, so how it was before is that the code said that all senators have to go to a new senator orientation, right? If you miss the first new senator orientation, you obviously have to go to a makeup within 2 weeks. But it doesn't specify within 2 weeks of what. But what we do know is that the R&E committee has to approve your excuse to be considered excused absent from the first new senator orientation. And if R&E doesn't approve your excuse, then you're not eligible to go to the makeup orientation, and then you get kicked out of Senate. But then also, sometimes R&E will get to your excuse later than 2 weeks after the new senator orientation actually happens. And so this just clarifies a problem that we saw this past spring. And it's been less of a problem over the summer because the terms are significantly shorter. But this type of thing is still necessary. It's simply just making the procedure significantly clearer than it was before. You can see that quite a lot was added. And then all of the thresholds and all of the timeframes that are outlined in this document are the same thresholds and timeframes that R&E uses in other parts of what they evaluate.
Is this supposed to be crossed out? Sorry, this will be striked out too, assuming.
Yeah.
You waive the rest of your time.
Yep, I waive the rest of my time.
We're now in line for 5 minutes of Q&A. Are there any questions?
Does this change the procedure at all? Like, if someone gets like brought in halfway through the semester, does that change the way that new senator orientation works? Because I know it's also kind of
No, yeah, if someone comes in after new senator orientation happens and they're like, come in like a couple weeks into when Senate already starts, the INC does have to give them a new Senate orientation.
Okay.
Yeah, but it's obviously separate from the original one.
Okay.
All right, I have some questions as well. Okay, so this isn't changing the penalty for students who miss this makeup?
No, if students miss the orientation and the makeup, you know, generally what happens is that you get removed, you're resigned by non-attendance, because the reason why it's not non-compliance is because the orientation excuses are evaluated the same way as just your typical meeting excuse. So you get removed by non-attendance. You have to be oriented within a particular time frame. It's the same consequence, same time frame of the precedents that we've been following. It's just making it clear because our interpretation was not super specific in the codes.
If someone has to be absent for the first one and the makeup, will they still be, like, in this legitimate absences, will they still be removed, or will there be another opportunity for?
I believe that's up to the INC chair if they want to do like a Zoom one for them or something. There was a bill that passed, I believe, that lets the INC committee do makeup orientations.
Yeah, I
on
believe
Zoom.
we had a Zoom one last night.
So I noticed it says provided the seat has not been filled. Isn't there a code that currently prevents us from filling a seat that's currently being appealed?
Yeah.
So,
So then I guess that would not apply.
okay. Yeah, because the seat can't be filled. Okay.
This exact wording was taken from another part just so that it was consistent.
Okay.
Yeah.
Are there any more questions? Seeing none, we're now on for 5 minutes of debate.
I think it's, I think in a way this provides more leeway to senators who missed that first meeting. If they, when you first come to Senate, it's kind of hard to know what's going on. If they miss that first meeting and either fail to submit attendance or maybe don't fully explain it, this way they're not at least getting removed too rapidly. And it gives the Rules and Ethics Committee a chance to hear them out on why they missed that initial meeting. I think it's good to codify this procedure.
Yeah, I've been in touch with a lot of new senators that have come in between summer A and B, and there has been a bit of confusion with the new Senate orientation, making sure that they get that. I know it's also a burden on the INC chair at times, so I like the things that this bill is doing. I think it's good. Maybe we should pass it.
Okay, we would have to, because this provided the seat has not been filled was written before the Sinclair Act, I believe, so this has to be stricken because the seat can't be filled.
Need to amend it.
Yeah, so we need to strike that section.
Do we need to do the one at the bottom too?
Yes.
Cool.
Is there any more debate? Seeing none, now in line for 2 minutes final privilege.
Yeah, that exact wording was copied from another part, so if you can find where that other part is and want to strike it there too, that would be great. I waive the rest of my time.
All right, we're now in line for any motions at this time.
I move to amend SSB 2024-1521 and striking the language about provided the seat has not been filled in Part 3, and also in Part 4, provided the student center has not been replaced in accordance with Chapter 340, seeing that they cannot be replaced under the current procedures. Did I say that right?
Yes, you did. Are there any objections? Seeing none, the motion passes. I'll go over it, yeah. So Section 3.
No, by
What? Oh, yeah, by unanimous consent?
Oh, yeah, sorry, by unanimous consent.
Any objections? Seeing none, that motion passes. So let me do that. You have the sections? Okay. All right, this word as well needs to be.
Which word?
That was an accident, yeah.
Oh, also, I move to amend SB 1521, strike the word Senate in Part 1 at the bottom. That is just not stricken out by accident. By unanimous consent, sorry.
Are there any objections? Seeing none, the motion passes.
I move to pass SSB 2024-1521 by unanimous consent.
Are there any objections? Seeing none, that motion passes.
Can't
Now
speak
in
to
line
that.
for the.
I have to go now.
Okay. All Okay.
No more quorum?
Yeah. Let me. Are there any motions at this time? I'll move to.
I move to adjourn by unanimous consent.
Are there any objections? Seeing none, that motion passes. This meeting has been adjourned at 12:33 p.m. on Monday, July 22nd.